SSC is supplier of electricity at notified tariff rate. The sale price included advance against depreciation, which is shown by SSC as sales in its profit and loss account. While computing the book profit, SSC deducted the AAD component from total sale price and took only balance amount into the profit and loss account. According to the Authority for Advanced Rulings, reduction of AAD from the safes was reserves which had to be added back on the basis of Clause B of Explanation 1 to Section 115 JB of the Income Tax Act 1961. On reading, it is clear that to make an addition under Clause B, the two conditions which must be jointly satisfied are that there must be a debit of the amount to the profit and loss account and the amount so debited must be carried to be reserves. Since the amount of AAD is deducted from sales, no debit in the profit and loss account. The amount did not enter the stream income for the purposes of definition of net profit at all. Hence, Clause B of Explanation 1 was not applicable. There are broadly two types of reserves, those that are routed through profit and loss account. For example, a capital reserve such as share premium account. AAD is not a reserve. It is not appropriation of profits. It is an amount that is under obligation right from the inception to get adjusted in the future, hence cannot be designated as a reserve. It is nothing but an adjustment by reducing the normal depreciation includable in the future years in such a manner that at the end of useful life of the plant, which is normally 30 years, the same would be reduced to nil. At the end of the life of the plant, AAD will be reduced to nil. Keeping in view the facts, the total profit and loss account will be different from the above. In fact, Schedule 9A to the balance sheet for the financial years 2004 to 2005 onwards indicated recouping AAD income received in advance. It is a timing difference and represents adjustment in future which is inbuilt in the mechanism notified by the income tax departments. The respondent, who was employed as a teacher under the government of Haryana, claimed advance increments in terms of Punjab government memo dated 1st September 1960. The Director of Secondary Education, Haryana, rejected the claim on the premise that in terms of Rule 10 of the Punjab Education Service Class 3rd School Cadre Rule 1951, the pay scales of the teachers were subject to variation from time to time, and since the state of Haryana revised the pay scales of various categories of teachers with effect from 1st December 1967, memo dated 1st September 1960 stood superseded. He also observed that highest start of pay with advance increments for postgraduate qualification was provided only to masters or mistresses and not to other categories of teachers. The High Court allowed the writ petitions and directed that the respondent be given advance increments in terms of the Punjab government memo and the letter of the government of Haryana. Aggrieved, the state of Haryana filed the appeal. The teachers employed under the government of Haryana could claim benefit of the higher pay scales, advance increments, etc. in terms of the policy decision taken by the government of undivided Punjab and instructions issued by it only till the revision of their pay scales, which were made effective from 1st December 1967 and not thereafter. The question of revision of pay scales of the teachers employed under the government of Haryana was considered by the Education Commission, which is also known as Kothari Commission. The recommendations made by that commission were accepted by the President of India and were implemented by the state government with effect from 1st December 1967. After revision of the pay scales of various categories of teachers, the government of Haryana issued instructions for grant of monetary benefits in the form of personal pay to those government servants who improved their qualifications by undertaking further studies within the country and abroad. Further, by later, all the existing instructions were superseded and fresh instructions were issued on the subject. However, the decisions contained in letter and other related communications were withdrawn by the state government by their letter. The High Court earned in accepting the plea of the respondents that revision of the pay scales of teachers with the retrospective date did not result in automatic supersession of the existing policy decisions. Unlike natural calamities that are beyond human control, avoidable disasters resulting from human error or negligence prove more tragic and completely imbalance the intergenerational equity and cause irretrievable damage to the health and environment for generations to come. Such tragedy may occur from pure negligence, contributory negligence, or even failure to take necessary precautions in carrying on certain industrial activities. More often than not, the affected parties have to face avoidable damage and adversity that results from such disasters. The magnitude and extent of adverse impact on the financial soundness, social health, and upbringing of younger generation may have been beyond human expectations. If such situations and where the laws are silent or are inadequate, the courts have unexceptionally stepped in to bridge the gaps to provide for appropriate directions and guidelines to ensure that fundamentals of Article 21 of the Constitution of India are not violated. The Bhopal gas tragedy is a glaring example of such imbalances and adverse impacts, where by courts intervention poor and destitute have been provided relief and rehabilitation. The Bhopal gas leak disaster occurred on the intervening night of the 2nd December 1984. Data reflecting the exact number of affected persons was not available initially. Earlier, it was felt that only a small number of persons were adversely affected in terms of health or otherwise by the leakage of toxic gases from the Union Carbide unit at Bhopal. However, the scientific communication for continuing study on effects of Bhopal gas leakage on life systems released a report titled The Bhopal Gas Disaster Effects on Life Systems in July 1987, which suggested otherwise. This report stated that for the estimated population of 2 lakh exposed to the toxic gases in the severely and moderately affecting areas of Bhopal and the variety of long-term problems anticipated in the crisis period, the number of exposés covered so far as by the Indian Council for Medical Research through the medical service constitute less than 20% of the population. With the passage of time, this figure of the affecting population has swollen to nearly 5 lakh. By the same scientific commission, it was also found that in general the output of the medical projects so far had not equaled the magnitude of the tasks assigned to them, presumably due to lack of resources, trained staff, as well as physical inputs. This has to be remedied in the shortest time so that project is completely fully. It is urged by him that the High Court has fallen into error by opining that there was no justification to exercise jurisdiction under Article 226 of the Constitution of India, whereas the facts stated warranted deletion of such an observation by the DRAT had really not addressed to any issue, and after recording a settlement in a most brief manner, recorded the observations which really deserves to be quashed by the High Court. It is further canvassed by the Council that the High Court should have taken note of the fact that the order passed by the DRAT had already been complied with, and it was absolutely unnecessary to drag the bank to a further litigation.